Today, we're diving into something I call the mediation trap. That tricky situation where you feel pressure to settle a claim that you know is completely baseless. We're going to look at a powerful legal strategy that tells you when it's not just okay, but actually smart to just say no. So just picture this for a second. You get hit with a lawsuit that has absolutely zero merit, but here's the kicker. The cost of actually fighting it in court is just astronomical. Suddenly, you're backed into a corner and settling feels like the only sane option, even when you know you've done nothing wrong. Well, what if I told you there's a way out of that corner? It turns out there's a legal principle that's been sharpened up and made crystal clear by a really fascinating UK court case. And it gives us a whole new playbook for dealing with this exact problem. All right, so here's our game plan. First, we'll break down the settlement leverage problem itself. Then, we'll get into the nitty-gritty of the key case, Grijns versus Grijns. That'll lead us to what's called the reasonable refusal rule. We'll zoom out to see the bigger picture, and then we'll wrap up with a practical playbook you can actually use. So let's be really clear about what we're talking about here. This isn't about two parties trying to find justice. No, this is about one party using the legal system itself as a weapon. They file a weak, maybe even a bogus claim, knowing that the other person might just pay them to go away to avoid the headache and, frankly, the insane cost of a court battle. The truth of the matter almost doesn't even factor in. And that's the perfect setup for our main event, the case of Grijns versus Grijns. It is a textbook example of someone successfully pushing back against exactly this kind of pressure. So what was this case all about? Well, on the surface, it looked like a family property dispute, but the UK High Court's decision was a bombshell. They found that the claimant's case wasn't just weak, it actually crossed a line and became an abuse of the entire legal process. And get this, the claimant was demanding a settlement of £900,000, a whopping $900,000. And this was for a claim that the court eventually said had no basis in reality. That huge number, when you compare it to the total lack of evidence, is what really started to smell like an abusive tactic. Now, the court's choice of words here is so telling. They didn't just say the claim was unproven or weak. No, they said the key parts were constructed. That's a powerful word. It basically suggests they were just made up. And the court pointed out that these claims flew in the face of existing documents and how everyone had actually behaved. So this case leads us straight to a really important legal idea, the reasonable refusal rule. This gives us a much clearer roadmap for when you can flat out say no to mediation without getting slapped with a penalty later. See, for a long time, the general rule of thumb was pretty simple. If someone seriously offers to mediate and you just ignore them, a court will probably see that as unreasonable and you could get hit with legal costs. But Grijns comes along and adds a huge clarification. It says, wait a minute, if the claim against you is obviously baseless or abusive, then refusing to mediate is actually perfectly reasonable. So the big question is, how do you spot one of these bogus claims? Well, the court in Grijns basically gave us a checklist of red flags. Does the claim clash with the paper trail? Does it just feel like it's designed to squeeze money out of you? Is the other side putting up silly, unrealistic roadblocks to mediation, or are their demands just completely wildly out of proportion? If you're taking those boxes, you might be in Grijns territory. Okay, so let's zoom out for a second. It's really important to get that while this Grijns case offers this amazing protection, it's happening at the same time that the global trend is pushing hard in the other direction for more mediation, not less. All over the world, from California to China, the push is on to make alternative dispute resolution, or ADR, a standard, sometimes even mandatory part of the process. And the goal is a good one: make our justice systems more efficient. So this Grijns case isn't some U-turn on that pro-mediation trend. Not at all. A better way to think about it is like a necessary fine-tuning. It's like a safety valve, right? It's there to protect the system and protect people from having it weaponized against them. And this isn't just a legal thing. It's part of a much bigger cultural shift. More and more in business and just in society, we're realizing that finding peaceful, efficient ways to solve problems is better for everybody. And that's the perfect environment for tools like mediation to grow. But it also shows exactly why we need these kinds of protections against their misuse. Okay, so let's bring it all back down to earth. What does this actually mean for you? Let's get practical and build your new playbook for how to say no to mediation when you're facing a baseless claim and how to do it without getting burned on legal costs. It really boils down to 4 key steps. First, document everything. Write down exactly why you believe the claim has no merit. Second, and this is a big one, always respond quickly to a serious request to mediate. Giving them the silent treatment is a huge red flag for a judge. Third, when you do respond, clearly lay out your reasons for saying no. And finally, if it makes sense, show that you're not just being difficult by suggesting another way forward. And this quote just nails it. This is the heart of the matter. Just because you have a duty to consider resolving a dispute doesn't mean you're forced to buy off a bogus lawsuit. You're not obligated to pay someone to drop a meritless claim just to dodge legal bills. Grijns confirms that the system does have its limits. And so we end right back where we started, with a fundamental question this whole situation forces us to ask. While the law can help us find the answer in any given dispute, you have to ask yourself, is this a genuine attempt at a fair settlement, or is it just legal blackmail?